Returning to my Coin Lady channel, I am pleased to see you again. I think it's safe to say that everyone has heard by now that the SEC is appealing Judge Torres' decision in the SEC v. Ripple case. As if to shock exactly 0 people, I released a video not long as Wednesday's news emerged that this was the case, and I spoke with a few lawyers whose opinions spread like wildfire. I posted some of CEO Brad Garlinghouse's remarks about this issue on my channel soon after the news broke, because he had some strong comments to say about it. Even though Jeremy Hogan was an attorney, he had not commented on the matter when I posted the video. I will inform you up front that Attorney Hogan believes this is a huge error on the part of the SEC, and I will not be shocked if, in the end, the SEC finds out, as the youth say, because he didn't share a fairly long post about his thoughts on the matter and its implications until after I had published the video. So, in any case, I'm simply going to show you the reaction that Attorney Hogan had to everything in this video. What a load of bullshit, though. It plans to appeal the programmatic sales ruling through the SEC. If successful, it will receive further funds from Ripple without providing any protection to anyone. Also, I need to take a moment to clarify this so that everyone is on the same page. Outside of on-demand liquidity on exchanges, when we speak about programmatic sales, we're referring only about Ripple's sales of XRP. So, these transactions remain in the dark for us. Since it might have been listed on an exchange, you would not have known that you were buying from Ripple. As in, what the hey? Perhaps it makes no difference, regardless of the transaction. Programmatic sales is what Ripple dubbed those deals. Ripple coined that phrase. The lawsuit proceeded to utilize that term because that was its official name. This is in reference to the fact that the SEC also utilized it in the litigation, specifically in the initial complaint. And of course, the signed transactions, this time from Ripple in particular. This is not about regular folks like you and me making purchases on Bitcoin exchanges. In fact, that is completely irrelevant. The lawsuit was never even about that. Ripple is the target of this particular litigation. The focus should be on the details of Ripple transactions, not on ripples between you and me, correct? Furthermore, XRP possesses regulatory clarity. Nonetheless, it is important to note that the SEC cannot challenge secondary market transactions involving individuals like you and me. For that reason, we should not be overly concerned. I would say that. Regardless, I believe it's quite evident. Additionally, he claims that Ripple would bring up its blue sky legislation issue, which, if successful, would render the SEC's capacity to oversee the whole cryptocurrency market moot. If the SEC were a stock trader, it would be terrible at calculating risk. Yeah, I see your point. I can't say for sure that I recall every detail of the blue sky law. When it came to issues like blue sky laws-based transactions and post-sale duties, I'm aware that Ripple had some points to make. To clarify, blue sky laws were enacted at the state level in the US before the inauguration of a federal president to safeguard the public against fraudulent securities offerings and sales. Prior to the passage of the Federal Securities Act of 1933, state laws served as precedent, correct? And those laws in the sky served as the foundation. That being said, that is indeed the point he was making. Second, he clarified that, unlike the SEC's prior attempts at an appeal, the trial judge cannot dismiss this appeal since it is an appeal by right. Okay? As an example, you might remember around the beginning of this year, they tried to file an accelerated appeal known as an interlocutory appeal with the SEC, but Judge Torres rejected their motion because she didn't think it made sense. She whacked him on the bottom. There are a lot of reasons why that can't be done right now, and I really doubt it will make a difference. Truthfully, I believe Judge Torres has drafted this in such a way that it's very watertight, but the judge still can't dismiss the appeal. Yes, it is correct. Thirdly, regarding Attorney Hogan's third point, the SEC is statistically and factually highly likely to lose, so I'll just pause for a moment to make a note of it. I was merely bringing this up, and Attorney Deaton brought it up as well. Actually, I think I already brought up the fact that this appeal is taking place in my video when I first brought attention to the fact that this case is being highlighted. However, Attorney Deaton brought up the point that, Judge Torres' ruling was based on one of the factors in Howey. For something to pass the Howey test, which means that it is indeed an illegal security transaction, it needs to meet all of the requirements of the test. According to Deaton, Judge Torres only considered the third prong when making her decision. Judge Torres responded by saying, well, yeah, and that's all she needed to do, by the way. This is because, as Deaton pointed out, if one prong isn't satisfied, it doesn't matter if the other ones are, as long as all are satisfied. We already know that there is an appeal, so if this is remanded, she can just rule on the other prongs. Consequently, she will succeed in her endeavors regardless. Therefore, it is masterfully written in that manner. After that, according to Hogan, this is the fourth point. Regarding XRP and its usage by Ripple, it is quite probable that nothing would change even if the SEC were to win on appeal. It is merely a matter of money. Just because he has 2 4s here doesn't mean you should pay attention to them. Thus, he has 8 points in total, with 2 of them being designated as 4s. Even after reading it a couple of times, I failed to notice that. In a couple of weeks, he will know which points the SEC is appealing, which brings us to point 4, number 2, it must file its first brief by mid-December. Pay close attention to whether the SEC decides to appeal the injunction. It will not be possible to do so, because XRP is not a security. Alright, so you can't challenge the fact that XRP is a security attorney in and of itself. Just after XRP, I saw Hogan, the first attorney I'd ever seen, and he explained why. Last year on July 13th, we celebrated XRP Victory Day. He pointed out that the judge's citation was dicta DCTA, and that XRP was thus determined not to be a security. Since she did not initially receive a request to rule on the matter, but subsequently included it, there is no procedural provision for appealing her decision. The SEC went even farther, penning an independent statement in which they said that XRP is nothing more than worthless computer code, which I have showed numerous times on my channel. The SEC did transmit that, and I'm paraphrasing, it was probably around the middle of August last year, or they wrote it to Judge Tor. Yeah, we're not going to appeal that. So even the SEC acknowledges that XRP's status as a security right is not a point of contention. Furthermore, with regard to the injunction mentioned by Hogan, it would just represent the SEC's intention to ensure that Ripple does not violate the login requirements or Section 5 offenses. The fifth point is that the appeal court will not issue a ruling until late 2025 or early 2026. 10 years from now, in the summer of 2025, I mentioned that it would take until 2026. That is where I was mistaken. My apologies. Forgive us. Tony Hogan, we are sorry about that. In all candor, it isn't, it's not really off anyway. Plus, I couldn't care less because, A, I value your work and, B, the ordinary XRP holder will be unaffected. This is relevant solely to you, the Ripple community, and nobody else. And I don't think there are enough people who are crystal clear about that from the start. And then he brings up point 6 in this context. Just because I'm wacky doesn't mean I can't accept that Attorney Gruel's announcement that he's quitting the SEC coincides with the filing of the appeal. I appreciate you taking the time to view my video. When you're done, hit that subscribe button and let me know what you think.